This is the issue, and I am the ghetto man in the control room today. We're all aware of the censoring that's going on in Google and Facebook and YouTube and Twitter. And the argument is that these corporations are private businesses, and because they're private businesses, they can set up their own terms and conditions and more or less police the forum for anybody that may or may not be abiding by their rules. And what we've seen that there has been an actual censoring of conservatives, Christians, and constitutionalists and other people who oppose this anti-American, constitutional-phobic communist agenda that's being pushed by the radical left. Well, anyway, there was a Supreme Court case in 1945. It's called Marsh versus Alabama. And what we have here is we have a corporation who literally owned an entire town. They owned the sidewalks, the streets, they owned all the buildings, all the stores, everything. They didn't own what was in the stores. They leased those out to people, and they operated their business just like you would in any other town. Well, anyway, there was this person who was a Jehovah's Witness, and they were on the sidewalk in front of the post office, and they were passing out their religious information. Well, anyway, it turns out that it violated the policies of this corporation who owned the whole show. Well, anyway, I heard David Knight on InfoWars the other day. He mentions this case, Marsh versus Alabama, all the time. Unfortunately, he doesn't have the time to review the whole thing, which that's too bad because I really enjoy listening to David Knight. He's one of the few people on the internet that really touches with our constitutional law, touches and it tries to explain to the public how it works. Well, anyway, what I'm going to do is I'm literally going to read through the case. It's not that long. It's only a few pages long. And we'll make some comments on it along the way. Anyway, the case is Marsh versus Alabama, and that can be found in the United States Supreme Court Reports, book number 326, U.S., on page 501. Now, I was going to read through the syllabus, but I don't think we have to. Let's just go to the opinion of the court, which I said is not really that long. That's why I want to read through it all the way. In fact, this is my first introduction to legal research. When I'm teaching people how to research the law, this is what you do. You hunt for the various different cases where the court has decided on a particular issue that you're interested in or that you're involved in, and then you go ahead and read these cases. And as you're going to soon see, it really isn't that difficult to understand. A lot of people, they think, oh my God, I can't understand a legal thing. Believe it or not, they're not that hard to understand. And when you read through them, really the light bulb goes on and you start to understand exactly how your constitutionally protected rights work. And what we're going to do is we're going to make the comparisons between this corporation with the corporations like Google and YouTube and Twitter and so on, that the same principles apply, okay? Well, anyway, it was Mr. Justice Black that delivered the opinion of the court. In this case, we are asked to decide whether a state, consistently with the First and 14th Amendments, can impose criminal punishment on a person who undertakes to distribute religious literature on the premise of a company-owned town, contrary to the wishes of the town's management. The town, a suburb of Mobile, Alabama, known as Chickasaw, is owned by the Gulf Shipbuilding Corporation. Except for that, it has all the characteristics of any other American town. The property consists of residential buildings, streets, a system of sewers, a sewage disposal plant, and a business block on which businesses places are situated. A deputy of the Mobile County Sheriff, paid by the company, serves as the town's policeman. Merchants and service establishments have rented the stores and business places on the business block, And the United States uses one of the places as a post office, from which 6 carriers deliver mail to the people of Chickasaw and the adjacent area. The town and the surrounding neighborhood, which cannot be distinguished from the Gulf property by anyone not familiar with the property lines, are thickly settled, and according to all indications, the residents use the business block as their regular shopping center. To do so, they now, as they have for many years, make use of the company-owned paved street and sidewalk located along the storefronts in order to enter and leave the stores and the post office. Intersecting company-owned roads at each end of the business block lead into a 4-lane public highway which runs parallel to the business block at the distance of 30 feet. There is nothing to stop highway traffic from coming onto the business's block, and upon arrival a traveler may make free use of the facilities available there. In short, the town and its shopping district are accessible and freely used by the public in general, and there is nothing to distinguish them from any other town and shopping center except that the title to the property belongs to a private corporation. Okay, I'm going to stop here just for one moment. I think most of you can see the parallels here when we're talking about Facebook, Google, Twitter, and these other corporations. The corporations own the platforms, and these platforms are like a town. They're people who communicate there and trade ideas, sell products. There's all kinds of things going on. It's just exactly the same thing as you see here. You have a corporation that owns all this, but all these people are involved in having businesses. They walk up and down the sidewalks. People can drive in and out. You can go to these websites as an example. You can go in and out. They're free to go. Nobody's there to stop you. Okay, moving along. Appellant, the one who was convicted here, a Jehovah's Witness, came onto the sidewalk we have just described, stood near the post office, and undertook to distribute religious material or literature. In the stores, the corporation had posted a notice which reads as follows: "This is private property, and without written permission, no street or house vendor or agent solicitation of any kind will be permitted." Okay? So this is like what, Google and Twitter have. They have these terms and conditions, and if you violate these terms and conditions, then you run into problems. So here we see this corporation has some terms and conditions when you come onto their format or they come into their town. Okay? Okay, the appellant was warned that she could not distribute the literature without a permit, and told that no permit would be issued to her. She protested that the company rule could not be constitutionally applied so as to prohibit her from distributing religious writings. When she was asked to leave the sidewalk in Chickasaw, she declined. The deputy sheriff arrested her, and she was charged in the state court with violating Title 14, Section 426 of the 1940 Alabama Code, which makes it a crime to enter or remain on the premises of another after being warned not to do so. Appellant contended that to construe the state statute as applicable to her activities would abridge her right to freedom of press and religion contrary to the First and 14th Amendments to the United States Constitution. This contention was rejected, and she was convicted. I want to back up for a second. It mentions the First Amendment and the 14th Amendment. Most people don't understand that the 14th Amendment, what it actually did is it made the first 10 amendments to the United States Constitution, that's the Bill of Rights, applicable upon the states. There was a time when the states didn't offer their citizens the complete protection of the Bill of Rights. And the 14th Amendment made sure that at least those first 10 amendments, the Bill of Rights, that the states have got to apply those, and they've got to honor those. The Alabama Court of Appeals affirmed the conviction, holding that the statute, as applied, was constitutional because the title to the sidewalk was in the corporation and because the public use of the sidewalk had not been such as to give rise to a presumption under Alabama law of its irrevocable dedication to the public. The state Supreme Court denied certiorari, and the word certiorari means denied review. And that case was 246 Alabama at 539. Okay, and the case is here on appeal under Section 237A of the Judicial Code 28 U.S.C. Section 344A. Had the title to Chickasaw belonged not to a private but to a municipal corporation, and had appellant been arrested for violating a municipal ordinance rather than a ruling by those appointed by the corporation to manage the company town, it would have been clear that the appellant's conviction must be reversed. Okay, I want to back up here for just one quick second here, and I don't mean to drag all this out here. Here's a prime example. We have these corporations that are, censoring people, censoring their First Amendment rights, and it's being done by the company. And it's not being done by some ordinance, which you couldn't have anyway. But it's the company that is making these rulings, not through some sort of judicial proceeding. Under our decision in Lowell versus Griffin, 303 U.S. 444, and others which have followed that case, neither a state nor a municipality can completely bar the distribution of literature containing religious or political ideas on the streets, sidewalks, and public places, or make that right to distribute dependent on a flat license tax or permit to be issued by an official who could deny it at will. We have also held that an ordinance completely prohibiting the dissemination of ideas on city streets cannot be justified on the grounds that the municipality holds legal title to them. Jameson versus Texas, 318 U.S. 413. And we have recognized that the preservation of a free society is so far dependent upon the right of each individual citizen to receive such literature as he himself might desire that a municipality could not, without jeopardizing the vital individual freedom, prohibit door-to-door distribution of literature. Martin versus Struthers, 319 U.S. 141. From these decisions, it is clear that had the people of Chickasaw owned all the homes and all the stores and all the streets and all the sidewalks, all those owners together could not have set up a municipal government with sufficient power to pass an ordinance completely barring the distribution of religious literature. Our question then narrows down to this: can those people who live in or come to Chickasaw be denied freedom of press and religion simply because a single company has legal title to all the town? For it is the state's contention that the mere fact that all the property interests in the town are held by a single company is enough to give the company power, enforceable by state statute, to abridge these freedoms. It goes on to say, we do not agree that the corporation's property interests settle the question. The state urges, in effect, that the corporation's right to control the inhabitants of Chickasaw is coextensive with the right of a homeowner to regulate the conduct of his guests. You following this? We cannot accept that contention. Ownership, now this is very important, ownership does not always mean absolute dominion. The more an owner, for his advantage, opens up his property for use by the public in general, the more do the rights become circumscribed by statutory and constitutional rights of those who use it. CF, Republic Aviation Corporation versus Labor Board, 324 U.S. 793. Thus, the owners of privately held bridges, ferries, turnpikes, and railroads may not operate them as freely as a farmer does his farm, since these facilities are built and operated primarily to benefit the public. I'm going to stop there. You're going to find out that any corporation, I don't care who they are, when they're incorporated, it is presumed that they're incorporated for the benefit of the public. And that comes from a case called Hale versus Hinkle. And matter of fact, let me go ahead and quote that right now. I think that's really important. It's a good place to bring this in. Well, anyway, in Hale versus Hinkle, the court said this. It said, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchise and holds them subjects to the laws of the state and the limitations of its charter. Its powers are limited by law. Now listen to this. It can make no contract not authorized by its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. And that's Hale versus Hinkle, and that can be found in 201 U.S. 43. Now, I brought that up because everybody always says, private corporations, they can do what they want. No, they can't. And this case here is so important. This is why I'm reading through the entire opinion of the court here, because I want you to, first of all, get an idea how legal research is done, and second of all, see how the law works. So you can sit here, and when you're on the internet and people are telling you, the private corporations, you can go ahead and quote this case. You can quote Marsh versus Alabama and says, no, the court said that's wrong. Now, this case is going to apply to Google, Twitter, and everybody. This is how it works. Okay, and I said, since these facilities are built and operated primarily to benefit the public, and since their operation is essentially a public function, it is subject to state regulation, just like it said in Hale versus Hinkle. All these corporations, they're all under control of the government. When the government tells you, these are private companies, we have no control, that is bull. They have complete control. They can pull their charter. They can do anything that they want. These corporations, they can uncreate them if they want to. Okay, continuing on, it says, and though the issue is not directly analogous to the one before us, we do want to point out by way of illustration that such regulation may not result in the operation of these facilities even by privately owned companies, which unconstitutionally interferes with and discriminates. Remember, I've talked to you about this before, that what these various different corporations are doing by censoring people, are discriminating. It's no different than discriminating against color. With and discriminates against interstate commerce. Port Richmond Ferry versus Houston County Supra. And the word Supra means that it's already been mentioned one time before in this case, or somewhere before. That was 234 U.S. at 326. And cases cited on page 328 through 329. South Carolina Highway Department versus Barnwell Brothers, 303 U.S. 177. Had the corporation here owned the segment of the four-lane highway which runs parallel to the business block and operated the same under a state franchise, doubtless no one would have seriously contended that the corporation's property interest in the highway gave it power to obstruct through traffic or to discriminate against interstate commerce. See County Commissioners versus Chandler, 96 U.S. 205, Donovan versus Pennsylvania Company, 199 U.S., and even had there been no express franchise, but mere acquiescence by the state in the corporation's use of the property as a segment of a four-lane highway, operation of all highways, including the segment owned by the corporation, would still have been performance of a public function, and discrimination would certainly have been illegal. We do not think it makes any significant constitutional difference as to the relationship between the rights of the owner and those of the public that hear the state. Instead of permitting the corporation to operate a highway, permitted it to use the property as a town-operated business block in the town and a street and sidewalk on the business block. And that they cite the case CF Barney versus Keokuk, 94 U.S. 324. Whether a corporation or a municipality owns or possesses the town, the public in either case has an identical interest in the functioning of the community in such manner that the channels of communication remain free. As we have hereinbefore stated, the town of Chickasaw does not function differently from any other town. The business block serves as a community shopping center and is freely accessible and open to the people in the area and those passing through. The managers appointed by the corporation cannot curtail the liberty of press and religion of these people consistently with the purpose of the constitutional guarantees. And a state statute, as the one here involved, which enforces such action by criminally punishing those who attempt to distribute religious literature, clearly violates the First and the 14th Amendments to the Constitution. Many people in the United States live in company-owned towns. These people, just as residents of municipalities, are free citizens of their state and country. Just like all other citizens, they must make decisions which affect the welfare of the community and nation. To act as good citizens, they must be informed. In order to enable them to be properly informed, their information must be uncensored. They start to see the relationships to what's going on with these, with Google and on all these platforms that are supposed to be social platforms, and community squares is what they call them. There is no more reason for depriving these people of liberties guaranteed by the First and 14th Amendments than there is for curtailing these freedoms with respect to any other citizen. When we balance the constitutional rights of owners of property against those of the people to enjoy freedom of press and religion, as we must here, we remain mindful of the fact that the latter occupied a preferred position. As we have stated before, the right to exercise the liberties safeguarded by the First Amendment, quote, lies at the foundation of a free government by free men, unquote. And we must, in all circumstances, quote, weigh the circumstances and appraise the reasons in support of the regulation of the rights, unquote. And that's a quote from Snyder versus State, 308 U.S. 147. In our view, the circumstance that the property rights to the premises were the deprivation of liberty, here invoked, took place were held by others, then the public is not sufficient to justify the state's permitting a corporation to govern a community of citizens so as to restrict their fundamental liberties and the enforcement of such restraint by the application of state statute. Insofar, the state has attempted to impose criminal punishment on appellant for undertaking to distribute religious literature in a company town. Its action cannot stand. The case is reversed, and the cause is remanded for further proceedings not inconsistent with this opinion. Now there's, so it was reversed and remanded. There is a couple of concurring opinions and a dissenting opinion here. I'm not going to get into them right now, but what I do want to do, just closing this thing up, is make the point. As I've been saying this all along, I've got several videos on corporations and corporations discriminating. The court is very clear here. When it comes to corporations, and as I read in Hale versus Hinkle, corporations they're presumed to be incorporated for the benefit of the public, and they are regulated. And so what we have today is we have a government. And I just recently saw that with a congressman who said he would like to be able to regulate free speech, but right now the Constitution prohibits that, letting us know that he, even though he's taken the oath to uphold and defend the Constitution, he doesn't agree with it. And we don't need those type of people in our government at all. And we've seen this with that Congressman, I call him Piggly Quigley, back there when they were, where Congressman is asking Facebook if they've removed InfoWars from their platform. And here you have a senator who took an oath to uphold and defend the Constitution. Since he can't violate your rights, he's trying to get what they created, what the state created, a corporation. He's trying to get that corporation to do his dirty work. So the next time somebody tells you that Google, Facebook, and Twitter, and all of these platforms that are censoring people, that this is discrimination. I mean, this falls under the Civil Rights Act. It goes on and on and on. What they're doing is totally unconstitutional, and they need to be reined in.